Hello everyone. I am Monal Joshi, your mediation coach.
And I am Nirza Basu.
Chapter 2, Module 5 of this training is Confidentiality and Privacy in Mediation. Confidentiality and privacy are crucial elements in mediation. Mediation is a voluntary and confidential process where parties in dispute work with a neutral third party, the mediator, to reach a mutually acceptable resolution. The principles of confidentiality and privacy help create a safe and open environment for the participants to discuss their issues openly and honestly. There are 5 basic principles how confidentiality and privacy are typically addressed in mediation, and I am sharing those with you now. First, confidentiality of discussions. Mediation discussions are generally considered confidential. This means that the parties involved, including the mediator, agree not to disclose the content of discussions outside the mediation process. Confidentiality promotes trust and encourages parties to speak freely without fear that their statements might be used against them later.
Second, legal protections. In many jurisdictions, laws and regulations protect the confidentiality of mediation. These laws often prevent the mediator from being compelled to testify or disclose information from the mediation session in a subsequent court proceeding. Parties can consult local laws to understand the specific protections available to them.
Third, mediator's role. Mediators are bound by ethical guidelines that require them to maintain confidentiality. They must not disclose any information shared during mediation without the parties' explicit consent, unless required by law or in exceptional circumstances where there is a risk of harm to an individual or the public.
Fourth, written agreements. Prior to beginning mediation, participants may be asked to sign a confidentiality agreement or a mediation agreement that outlines the expectations and obligations regarding confidentiality. This agreement typically emphasizes that information shared during mediation is to remain confidential and may not be used as evidence in any legal proceeding.
Fifth, exceptions to confidentiality. While mediation is generally confidential, there are exceptions. For instance, if the parties reach a legally binding agreement, that agreement may be enforceable in a court of law and therefore not subject to confidentiality. Additionally, mediators may be obligated to report certain issues, such as child abuse or threats of violence, to the appropriate authorities. It's essential for parties to have a clear understanding of the confidentiality and privacy provisions specific to their mediation process. It is recommended to consult with the mediator or legal professionals involved to fully comprehend the scope and limitations of confidentiality in a particular mediation. That is all in this video. In the next video we are sharing Chapter 3 of Module 5. Thanks for watching.
And stay tuned for more.